This is a continuation of Justice for South Dakota, and we will be looking at Episode 9, Decades of Corruption Within the Justices, including biased rulings against pro se litigants in the South Dakota 7th Judicial Circuit Court. Remember that these recordings come at a very high price, including imprisonment, because somebody dares to speak out. The only thing that I can ask you to do is to continue to share my YouTube channel and the message so that by sheer public opinion of the citizens of South Dakota, justice will be done. So what is a pro se litigant? Well, a litigant is somebody who's involved in a lawsuit, and pro se is Latin for proceeding on your own behalf. If you are served a copy of a lawsuit in South Dakota, you also are served a summons, which is a court order saying you have to respond within a certain amount of time frame. Usually it's anywhere from 20 to 45 days. And if you fail to respond, then the judge will rule against you and give the plaintiff the relief that they're requesting. So the absolute best way to guarantee a loss is to not reply. When America was first established, it was not a normal occurrence to have an attorney represent you in court. Most cases were presented by the two parties to the lawsuit, the prosecutor and the defender, or the plaintiff and the defendant, and a judge issued decisions according to the law. It was black and white rulings because the people have enacted statutes or codified laws that tell a judge exactly how to rule. And it was very, very simple. However, in the last few decades, it has become a matter of you have to pay $100,000 to $200,000 in attorney fees. If you don't have the money, you're forced to go to court yourself. And so Texas has taken a leading stance in the nation where their former Chief Justice Wallace Jefferson admitted that all litigants should be represented not only by counsel, but by competent counsel. And until that ideal is achieved, because Texas has so many illegal immigrants and unrepresented parties in court, they have really implemented a way to help ensure that all litigants are allowed an equal day in court. So there are times in our life when being involved in a court case is unavoidable, such as divorce. What happens if your spouse files for divorce? Child custody, visitation, consumer scams, guardianships, healthcare, probate issues, etc., etc. There are many, many reasons why you go to civil court, not just committing a crime. And it was admitted that only about 20% of people eligible for legal aid services are able to get the assistance that they need, which leaves a very large majority of people who are now pro se litigants because they cannot afford a private attorney. And Texas admits that the court system was designed for attorneys and that pro se litigants are pretty much facing an extremely uphill battle. The South Dakota Supreme Court admitted this fact as well. So if you are involved in a criminal matter and you cannot afford an attorney, the state is required to grant you an attorney, and then the state has to pay that attorney for the representation, and the person being accused is placed on a payment plan and paying the state back little by little as they obtain money to afford the payments. However, 7th Circuit Court ruled that even the state-appointed attorneys were not allowed to receive payment for their services as was required. So the Sixth Amendment to the United States Constitution guarantees the right to counsel. This is where states have to appoint public defenders for the accused. And the South Dakota Supreme Court admitted that lawyers are necessities, not luxuries. Their presence is essential because it's only because the person is represented that their trial rights are secured. Otherwise, without counsel, the right to a trial would be of little avail, and it is by far the most effective right that a person has, because the South Dakota Supreme Court admitted that if a person does not have an attorney, it's pretty much a useless case and all their other rights will be violated. This was in Duffy v. Circuit Court, 7th Judicial Circuit, 2004, South Dakota Supreme Court ruling number 19. Why is this so important, and why am I bringing it up? Well, it's because we're looking at perversion in the justice system, specifically Pennington County, and how Kristi Noem is fully aware of this perversion, turns her head, and Justice Jensen is 100% involved in this perversion. So this particular case, the 7th Judicial Court appointed Veronica Duffy, an attorney at law, as a counsel for 4 separate criminal cases with 2 accused people. And Circuit Court Judge Jeanine Kern, who is currently a South Dakota Supreme Court Justice, states that she had the greatest personal respect for the attorney's abilities. However, Justice Kern said that she had limited budget for court-appointed attorney fees, and the court bears the duty and obligation to make sure that this budget is not exceeded, so therefore she cut the bill of the attorney down by almost $6,000, $50 short of $6,000. Well, Veronica Duffy, the attorney, contested it, so then they had a panel of 4 judges, including Judge Kern, the one who did the original order, Judge Tice, again, important to remember this, Judge Davis, and Judge Trimble. They all considered the law, they all considered the action, and they ruled that the action was within the law. Remember, Judge Kern is currently a South Dakota Supreme Court Justice. So Veronica Duffy appealed it to the South Dakota Supreme Court, and the justices at the time that were on the Supreme Court found that the Circuit Court failed to apply the correct legal standard and failed to abide by the law. Therefore, they remanded, which has sent the case back to the 7th Judicial Circuit to apply the correct standard and procedure. Was this an isolated case? Remember, this is 2004, South Dakota Supreme Court ruling 19. Well, this is 2004, South Dakota Supreme Court ruling number 20, the very next one. Again, involving a criminal defense attorney, Rena Atchison. She was court-appointed to represent another defendant charged with child rape and 3 counts of sexual contact with a child. Obviously, this would be a bit more of an in-depth court appointment. And this time, it was Judge Tice who refused to pay the attorney Rena Atchison for her appropriate services rendered. And again, there was a panel of the 7th Pennington County judges that were appointed to review it. And the exact same judges said, nope, Judge Tice is right. So here you have Judge Tice ruling on Judge Kern's case, and you have Judge Kern ruling on Judge Tice's case. They're both just patting each other's back. And again, Rena Atchison, the attorney, appealed it to the South Dakota Supreme Court, and the justices at the time found that yet again, all the justices in Pennington County failed to apply the correct law in doing it. They did not pursue its authority, and therefore they sent the case back to the 7th Judicial Circuit to apply the correct law and procedure, same as they did in the case right before. What happens if you're pro se and you have to go to court? Well, it is a well-known fact that pro se litigant's not going to win. It's so well known that the American Bar Association back in 1998 published a educational piece for attorneys calling it Avoiding Goliath's Fate. And this document outlined as attorneys how to avoid losing to a pro se litigant. And back in 1998 created a huge bias in the judicial mind that attorneys can never lose to a pro se litigant. This bias has skyrocketed from the 1980s, 1990s to today, so much so that there was a series of studies done investigating if this bias truly existed and if self-represented pro se litigants face additional biases by actual judges. And this nationwide study was found that yes, it does. Even though they're supposed to be unbiased and equal deliverance of the law, the judges will rule against pro se litigants, and this is sky high across the board in Pennington County, South Dakota. Judge Richard Posner is an important player in this podcast here. He actually served on the Federal Circuit Court of Appeals for the 7th Circuit Court since President Ronald Reagan appointed him. He authored more than 3,000 opinions. He clashed with his fellow judges over the way the 7th U.S. Circuit Court of Appeals treated pro se litigants, and because of his disagreements and his request that everybody be treated equally, he was forced to retire approximately 10 years prior to what he should have. And he also said that about 55 to 60% of the litigants who file appeals in the 7th Circuit represent themselves as pro se, and they are not even given the right to argue their case. Their cases are immediately dismissed. Now, Posner was persecuted after he retired with his forced retirement because he went public about this injustice, and he wrote a book. He did interviews with the New York Times, and he said that he was going to dedicate his post-retirement to helping people without attorneys, because he was so convicted by how judges are mistreating pro se litigants. In an attempt to bring national recognition and hold judges accountable, Judge Posner wrote a book on the extreme bias against pro se litigants in the court system. And this book is for sale on Amazon. I have included the ISBN there for you. He also is requesting, as a measure of accountability to the judges, that video cameras be allowed in the courtrooms, because if you sit in on actual hearings, you will see how if you're a pro se litigant, there's extreme bias in the courtroom towards you, and the threat of being publicized on TV with video cameras, such as what happened in Johnny Depp and Amber Heard's trial, it would hold judges accountable. And Justice Posner's request has been greatly ridiculed among the justices. Now, I'm sorry to all of you ladies out there who are amazing women and named Karen, but Judge Karen Cole is a true Karen. She is one of the Florida's 4th Judicial Circuit Court. She was giving a speech to all of the incoming attorneys for the Jacksonville Bar Association. It was over 50 young attorneys, and she's right there all the way on the right. She specifically said in her welcoming speech to these 50-something young attorneys, brand new graduates, that people who are pro se generally fall into one of two categories, and she called them crazy. Those who aren't represented by an attorney for financial reasons, and those, quote, who are unbalanced, unquote. If they're in the second group, be polite, but do everything you can to completely annihilate the people in the first group. The well-known prejudice against pro se litigants is being contended by brave attorneys, including this Jonah Goldschmidt of Seattle University School of Law. She released a article in their magazine on May 30th, 2021, bringing up the fact of how many judges refer to self-represented litigants as pests or kooks. And the U.S. Constitution requires that all people are treated equally, and judges are not supposed to be biased. Having an attorney lose to a pro se litigant is such a severe setback, a perceived setback for the attorneys, that the professional liability defense even issued an article on how attorneys cannot lose to pro se litigants, and again feeding this bias. So the article on the left there, I believe, was released in 2020. And then on the right-hand side, the Institute for the Advancement of the American Legal System conducted a study through Oregon, Colorado, Massachusetts, and Tennessee, 128 different parties and 49 different courts. And they found that while most pro se litigants wanted legal representation, they couldn't actually afford it, and that they were forced to appear in court on their own behalf due to financial reasons, and that they definitely were at a disadvantage and experienced bias because of their pro se status. The American Bar Association recognizes this great problem across the nation and actually released training modules on how judges need to take all these tests and identify their biases and then correct them or be removed from the bench. These slides are taken directly from that presentation. So the American Bar Association is trying to educate judges on what a bias is and how to identify the biases, and then combat the effects of the bias in the courtroom, both by prosecution, jurors, and also defense. So the American Bar Association pointed out that there's actually a lot to biases, and your conscious level is just the tip of the iceberg, because you're actually forming opinions and decisions based on personal biases at multiple different levels. And the whole purpose of this training module and all the tests, the self tests that they need the justices to take to recognize their biases, are actually for the preconscious, subconscious, and unconscious levels. And I would encourage you to go to this web page here that's open for any public person to take it as well, and look at what the justices are supposed to be doing. The American Bar Association pointed out that a judge is required federally, and this is across every single state, they cannot waive this, to perform their duties without bias or prejudice. So in other words, all these biases based on race, which we've discussed in the earlier episodes, based on gender, which we've discussed in the earlier episodes, based on social status, and now currently based on pro se status, are also federally barred. The people of South Dakota took the federal judicial canons and implemented them into state law. When a justice takes the office, he has to swear under oath in front of everybody that he will uphold the judicial canons. And this is Canon 3. A judge shall perform the duties of judicial office impartially and diligently. And it requires right there in section B-5 and -6 that the judge must perform the judicial duties impartially and fairly, and that any judge who manifests a bias on any basis, including against women, people of color, social status, etc., or pro se litigants, impairs the fairness of the proceedings and brings the judiciary into disrepute. And this includes upholding any attorney who exhibits bias and issuing sanctions against the attorney or removing them from the courtroom. It also states that a judge is not allowed to proceed in what they call ex parte communications. So in the interest of fairness, any communication with a judge must be made with all parties' knowledge and presence. So you're not allowed to send communication to a judge without including the opposite party. This is going to be very important for the upcoming episodes. as we're going to point out how the justices in South Dakota repeatedly engage in ex parte, which is one-sided communication with the opposing party who bribes them. And I have this in court case after court case after court case. This is where these justices have violated the judicial oaths and the South Dakota implemented guidelines which constrict how they're allowed to rule, and therefore these judges need to be impeached and removed from office. Any person can Google cases and find ruling after ruling after ruling in Pennington County and also the entire state of South Dakota. But remember, we're focused on Pennington County at the moment because it's the second most populated district, and it leads the state in perversion in the judicial system. Anyways, here's just one case from 2020 that was decided by the Supreme Court. And Dakota Lee Zerbst appeared pro se. He brought a case against the state on the basis of discrimination against a pro se litigant and also his religion. He happened to be a Messianic Jew. And he said that recusal is required if the judge bears a bias against pro se litigants, which is very accurate because the prejudice or bias would call into question the justice's impartiality. And upon review, it was found that the court had dismissed 3 of Dakota Lee Zerbst's pro se cases exhibiting a bias. However, they also dismissed this one as well. Couple other cases for you is Amy Lewis versus the South Dakota. So she actually was involved in a civil suit with her former significant other, and Pennington County justices took custody of her child away. Now, Amy Lewis is white. She is not a person of color. She is simply a mother who is white. And remember that the justices are extremely biased against people of color when it comes to children, but they are repeatedly taking children away from mothers in Pennington County. And this is case after case against evidence without following due process of law. And so Amy Lewis actually sued the justices of 7th Judicial Court, Pennington County, and her case was dismissed. They refused to even look at it because the judges have this mentality where they're going to cover up each other's errors. They're no longer going to allow themselves to be open to public scrutiny because it would require that they be impeached. And that's also why I'm doing this, is to hold these justices to public opinion, public accountability. And so Amy wrote that filed her complaint because the state of South Dakota revoked her parental rights without any preponderance of evidence and violated the due process clause of the 14th Amendment. If you refer back to the earlier episodes, I went into detail how they've done this extensively. And second is McPeak versus unknown Pennington County officers. And he was a pro se litigant, and his motion was also immediately denied and his case dismissed. So if you're a pro se litigant forced to go to court in Pennington County, South Dakota, what's the batting average? Well, you've got 0 wins. If you're represented, guaranteed to win 100% of the time against a pro se litigant. So again, we're asking Kristi Noem, she is fully aware of all this, to hold the hold the justices of South Dakota accountable. Kristi Noem is legally required to do this or be impeached herself, and I'm simply asking that she do her job. I'm going to continue exposing these justices and their illegal rulings. And I'm going to continue asking the residents of South Dakota to hold these elected officials accountable. So this is why I'm speaking out, because discrimination needs to end. Judges need to be placed on the bench who rule according to character, crime committed, and the individual's actions without looking at the color of your skin, gender, ethnicity, social status, or how much money you pay the court in bribes. These episodes are like chapters in a book. They won't make total sense unless you start at the beginning because they all build on each other. So episode 1 is Exposing Kristi Noem, South Dakota, and they're all on my YouTube channel. Episode 2 is What Determines Authority. And that's based on the United States Constitution and the South Dakota enacted laws. Episode 3 is Establishing Jurisdiction, how a judge is even allowed to exercise the authority to rule for you. Episode 4 is Who is Timothy John Evans, and what perversion is he involved in? Episode 5 is What Was It Worth? Why did Justice Connolly risk his entire career as a brand new appointed judge on ruling for Timothy John Evans? Episode 6 is Follow the Money, because it all goes right back to money. Episode 7 is called Stealing the Children, and it shows how person after person is having their children taken away from them. And it also ties right into perversion in the police force, because the law enforcement officers who are working with DSS are hand in hand with Mitch Johnson, involved in who is an attorney at law, and involved in a secret brotherhood. Again, this is Justice for South Dakota. It is a privately funded public accountability effort, and donations are welcome. Please share this with all of your friends and fellow South Dakota citizens.